hi Rajiv, Kamal here from merasangeet.com and a warm welcome to you once again on our show Chat in Chai.
Hi Kamalji, Pranam, how are you?
I'm very well, thank you Rajiv. How about you?
Very well. Yeah, I wanted to take about 5-10 minutes to go over a bill that has been introduced in the Senate yesterday.
Mm-hmm.
And in the meantime, if we have any issues that we want to discuss while I'm talking about this, please go ahead. So let me get started.
Absolutely.
Yesterday, which is Tuesday, January 13th, 2015,
Mm-hmm.
something called an Immigration Innovation Act. It is designated as of 2013, but it's been introduced in 2015. They also call it the I Squared Act because immigration innovation, so I Squared. And the bill number is S169. On the screen in front of me, of course, the radio audience cannot see it. From immigration.com, my blog, I have opened
Mm-hmm.
my commentary as well as a summary, official summary of the bill. So, what does this bill do? It has a number of very, very good provisions. It's a short bill and it deals only with legal immigration, employment based immigration. Okay, 99%. There's a small part that deals with the Chinese Student Protection Act, which is separate, but the most of the bill deals with legal immigration. So first of all,
Okay.
the H-1B visas numbers are being increased tremendously. Of course, this bill is not passed yet. We don't know what's going to happen in the end. But right now, the body of the bill looks like this. The number of H-1Bs will be increased from 115 to 300,000. Right now, it's 65,000. So it depends upon the market conditions. They have an allocation formula. And then this bill particularly notes that people who are the spouses of H-1B workers will be allowed to work and they'll be given work authorization. We have a regulation pending right now. I thought that the fact that legislators, senators have acknowledged a need for this provision is a good sign, even if the bill doesn't pass. A lot of these bill provisions are a good sign in the same way because they show a bipartisan recognition of some of the big problems we have in legal employment-based immigration right now. Okay,
Okay.
so I
Mm-hmm.
think as at the very least we've got this nod and this tacit consent, if not explicit consent, from the people on the Hill, our congressmen, that really these are some of the problems they recognize that need to be fixed. They are really one of some of the most painful issues. So we've got the EAD for H4 holders. Then we've got this interesting provision that says, look, if you've given somebody an H1B or an L1, these professional visas, and they apply for an extension, don't just deny the extension unless there is something really, really majorly wrong with the earlier determination. We've been having this problem as a practical matter that we keep running into this situation. We've got the H1 approval or the L approval. When we go for an amendment or an extension, they deny that
Uh-huh.
without any regard to the earlier determination of approval. So all of a sudden, I've got three people working on a project, and I've lost their H1s, and I can pretty much do nothing about it. If I file an appeal, it takes many months, but they can't stay in the United States in the meantime. So Congress has recognized that this is a problem, and they have admonished USCIS to make sure that they don't go back on their earlier decisions. Okay.
Uh-huh. Okay.
Then there's a very interesting provision which used to be there, I think, back in early 2000s. There was a provision where if I have an H-1B visa stamp on my passport, I, in order for me to renew the stamp, I don't have to go back to the consulate. I can do it within the United States by sending my passport to Washington, D.C., and requesting what is called visa revalidation. They are reinstating that provision if this bill passes for e-visa holders, which is the treaty traders, treaty investors, H visa holders, L visas, O visas. So basically, um, what this does is it creates a lot of consistency and certainty. Otherwise, what happens is, again, I've got an employee working on a project. If they go back to, let's say, India to get married, next thing is they are stuck for 6 months while the consulate says they are doing some investigations or administrative processing. It's become very difficult to predict when a visa will be issued. So this provision aims at removing that problem. If you already have a visa stamp, in order for you to renew that stamp in the same category, you will all you have to do is do it within Washington D.C. within USA. Okay,
Okay.
uh,
Okay.
very important provision for foreign students. Right
Mm-hmm.
now, student visas can be denied almost without any reason, as long as the consulate or the consular officer determines, oh, you know what, this guy is not going to come back, or this lady is not going to come back. I'm not giving you a student visa. So Congress has said that is not a good enough reason. Okay,
Rajivji, here, what about the students who are already in the United States doing a course, pursuing, let's say, their graduation, into their graduation courses? So, what about them? Is it okay? I mean, if they come back to India in between, for their holidays and then go back, or there's going to be some problem with them here also?
we don't know the exact details of the visa process, but right now, as the situation exists, most students have a visa that is several years. So
Okay.
usually, and it's a multiple entry visa, at least for India. Some other countries it may not be, but most countries have a multiple entry visa stamping. So student can come and go as they please, as long as they are maintaining status of a full-time student. They can come and go as they please. What will happen is, for students who are applying for a visa stamping for the first time, or whose visa stamping has expired, they will have a much easier time.
Mm-hmm. All right.
Okay. So another thing, remember we've talked about this, Kamalji, a couple of times, eliminating per country quota. Right now, for employment-based green cards, the problem is uh, there is the same number of, let's say, 7,000 green cards for each country, and we don't care what the population of the country is. If you're India with almost 1.3 billion people, or Vatican City with only 850 population for the whole country, you get the same number of visas, same number of green cards. And if the green cards by Vatican City are not utilized, all 7,000 of them go down the drain, they're not reused. What they're doing is they're saying under this bill, we'll remove the per country quota, everybody draws visas from the same bucket. Well, what that will do is it will tremendously work towards very efficiently work towards removing the backlog for people in employment-based categories, where some people have been waiting 6, 7, 8, even 10 years to get a green card. And these are people who are employed, who are stuck in a situation where they cannot change jobs or at least get promotions. It's a very difficult situation for employment-based green card applicants. So this provision, along with a couple of other provisions that go with it, removes the
Mm-hmm.
backlog very efficiently and very effectively.
Okay.
Okay. Um,
Okay.
it also allows for recapturing unused employment-based green cards all the way back from 1992, which is almost like a shot of adrenaline in a human being. The moment we get this
Mm-hmm.
provision passed, immediately you will see a tremendous increase in the rate of visa green card issuance. So yeah, I think it's a very good idea. This bill is looking really good. And then another thing is that they are also not going to count the children and the spouses of employment-based immigrants as visa applicants. Let me explain. Right now, if a family of five applies based upon the wife's green card, let's say the wife is the worker, she's filed the green card, and the husband and three children or two children are going with them, they are all counted as a separate green card against the quota. What Congress is saying or Senate is saying is that we will not do that. We will count the whole family as one green card,
Okay.
which is another
Okay.
very good provision.
Mm-hmm.
Okay, so
Mm-hmm.
these are the,
Mm-hmm.
in a nutshell, these are the main provisions. Now, I want to point out a couple of things. First of all, this is a bipartisan bill. That means both sides on the aisle, which is the Republican Party and the Democratic Party, have agreed that this is a good idea, but not all of the party, but some senators, six of them. Okay, they're called the Gang of Six. Okay, but
Okay.
remember, in Senate, we've had this happen before. Senate had earlier passed a complete bill. But now what they're doing is they have reduced the bill to a shorter set of provisions. So instead of a comprehensive immigration bill all at one time, it appears that they've targeted those areas where nobody should have too much of a problem, saying that this needs to be corrected and this is a good way to correct it. Okay,
Okay.
so one On the negative side, this has happened before, it didn't work out. On the positive side, what the other house wanted, which is the House of Representatives, wanted was a set of smaller bills addressing each problem in immigration law discreetly. This goes along with that. So, to that extent, it would have a better chance of being entertained by the lower house or the House of Representatives. Here we don't consider them lower or higher. So I think there are some good points and there are some not so good points. There are people who are not going to like this bill. Jeff Sessions is one of the congressmen I can think of who's not going to like this bill because they feel that H1 quota should be reduced, not increased, and foreign workers should be discouraged from coming into the United States, especially the STEM workers, the science, technology, engineering, mathematics workers. It's a very, very strange set of beliefs, but there are people who believe that, and everybody has a right to believe and act on that belief as far as it's legal. So that's in a nutshell what we are looking at. We are keeping a very close eye on this bill, how it moves through the House, how it moves through the Senate. We are excited. We like this very much. It's a very, very good bill for people who have been suffering from this long delays, the employers as well as the employees. I think this is a step in the right direction.
Okay, all right. So, Rajiji, I'm sure a lot of our listeners there tuned in, would be very happy with the new developments here. And in case they do have any queries, they can certainly write into us at kamal@mirasangeet.com or reach you directly as well on your website, that's immigration.com. So now we have one query here, Rajiji, from one of our listeners here,
Yes.
who says he is still in the process of getting a green card. And during this process, he says he wants to change his job from the present one to another one that is more, he finds it more challenging and much more better than what he is now, where he is now. So he says, would this in any way affect his getting the green card, or would it not? So, is it advisable to switch jobs now at this juncture, or no?
Has he see here is an example of the problem. So here we have employment based people who are good workers, very skilled people, and they have a lot of trouble changing jobs or advancing in their careers because technically while the green card is going on, even if you take a promotion, you could end up losing your current green card and have to start all over again, at least part of the
Okay.
process. So this is not a good thing. But let's take a look at what stage he is at. Has he mentioned what stage of green card he's at?
No, Rajati, he hasn't mentioned anything else
Okay.
except the fact that he is still in the process of getting his green card.
Do we have 3 4 minutes to cover this topic? I think it's an important topic.
Yes, yes, Rajati,
Okay.
absolutely.
Let me explain to you, keeping in view the current law, what Obama has said on November 21st about his plan, and finally what this bill says. Okay. First of all, under the current law, if you change employers before your I-140 approval is obtained, you will lose everything. You have to start all over again. Okay. So before
Okay.
I-140 is approved, that means if you are an EB1 based candidate, your I-140 must be approved. If you are an EB2 or an EB3 based upon labor certification, your POM application must be approved, and then your I-140 must be approved. Remember, I-140 can be filed premium processing, so you got to get your I-140 approved very quickly. Okay. So generally speaking, if you move before I-140 is approved, you get nothing. If you move after I-140 is approved, but before 485 is filed, you keep your priority date and you keep the right to extend H1 beyond 6 years as long as the I-140 is not revoked. Important concept to remember. You keep your priority date, okay?
Mm-hmm.
That means when you go to the next employer, you will have to start the green card all over again. But your priority date will be the date the first case was filed, which is a very big advantage, okay? So
Okay.
the priority date is capped, but here is an additional provision. If your priority dates are current and you have filed 485 with that old employer, after 180
Mm-hmm.
days of the 485 pendency and I-140 approval, you can take any job anywhere with any employer and be able to carry the same green card forward without having to redo any work. Okay, so before I-140 you get nothing. After I-140 and before 485, you get your priority date and you get the right to extend your H1 beyond 3 years, or beyond 6 years, sorry. And after I-140 approval plus 485 filing, 180 days thereafter, you get the right to keep your green card even if you take a slight promotion with another employer or move to an entirely different employer, as long as the jobs are same or similar. Okay. President Obama
Okay.
said normally you can only file the last step, the I-485, if your priority date is current. He says, I'm going to change that. I will allow you to file your I-485 along with the I-140, no matter where the priority dates are. Big advantage. That means technically, just roughly speaking, once you start your green card process through PERM, in a year and a half, you could be free to join any employer, approximately, okay, or 2 years at the most.
Okay.
As long as you maintain your the job category that you are in. And President Obama also said he's going to make it clear that advancement in career is considered to be same or similar job, so that your green card will not be disturbed. And that idea has been welcomed, very welcomed, and I don't think it has too much resistance from anybody. Okay. Now combine that with the Immigration Innovation Act, you could be getting your green card much earlier than 3, 4, 5, 6, 7, 8, 10 years that you are waiting for right now. So all these things combined are very, very good signs for people in a situation such as our listener, our friend who sent us this question has. So to him, I'll say, if you have not yet gotten your I-140 approved and you're far from that stage, okay, leave, as long as you don't have any H1 problems. If you're about to get the I-140 approved, wait, get the I-140 approved. If you have an H1 issue beyond 6 years, make sure the second H1 is approved before you change employers. Once the H1 is approved for 3 more years, even if the old employer revokes the I-140, they cannot take away your right to the H1 you've already gotten. Okay, so you can start another green card and protect yourself. This may sound a lot of Latin and Greek to people who are not involved in this process, but people who are involved in this process, even though I'm going pretty fast, should be able to understand what I'm saying.
Okay. So, Rajivji, that's one query that we received on mirasangi.com this week. And thank you so much today for the detailed discussion, for all your time with our listeners here on Mirasangi. Thank you so much and have a great day ahead.
You too, ma'am. Thank you very much. Bye bye.
Thank you, Rajivji. Bye bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202 800 8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.